All right, this is file 24-21915-FH, 24-21916-FH, and 25-22117-FC. People versus Michael Ronald Goble. We are here today. We had originally been scheduled for hearing on a motion in limine to allow video conferencing testimony. It's my understanding at this point that plea agreement has been reached and Mr. Goble will be entering the plea today. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Ryan Fry for Michael Goble.
All right, and record should reflect I do have a signed advice of rights form from Mr. Goble. Is it accurate, Mr. Fry, that Mr. Goble intends to enter a plea today?
Yes, that is accurate, Your Honor. There was a written plea agreement that was just made and I think emailed to the court where Mr. Goble would plead no contest to 3 counts of criminal sexual conduct, 2nd degree. 2 of those would be in file 24-21915-FH, which would be counts 1 and 2. And then there's an added count 2 in file 25-222-2117-FC. The added count again is criminal sexual conduct in the 2nd degree. All other remaining counts would be dismissed, as well as the entire file of 24-21916-FH would also be dismissed. And there's also a stipulation as part of the plea agreement that victim impact statements can be submitted from people that their case didn't result in a conviction.
Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, and I assume Mr. Fry talked to his client about it, but the conviction of these crimes will result in the defendant being required to register under the Michigan Sex Offender Registration Act. So I just want to make sure that was on the record and agreed to.
That is accurate, and I did discuss that with Mr. Goble, so I think he does understand that.
Okay. Mr. Goble, would you raise your right hand, sir? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Michael Ronald Goble?
Yes.
Mr. Goble, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contests today in file 24-21915-FH to count 1, criminal sexual conduct 2nd degree?
Yes. Yes.
Do you understand that the maximum possible penalty for that offense is up to 15 years in prison?
I do now.
Does that change your decision in any way?
No.
Do you also understand that a conviction to that offense would require lifetime electronic monitoring upon parole?
You said this.
That doesn't mean that you have to wear legal monitor. That just means that you have to be on the sex offender registry.
Yes.
Is it also your intention to plead guilty today to count 2 in file 24-21915-FH? Again, criminal sexual conduct 2nd degree, a 2nd count of that offense.
Did you say plead guilty to it?
I'm sorry, if I said guilty, I meant to say no contest.
Yes, no contest.
Okay. And do you understand that the maximum possible penalty for that offense is also up to 15 years in prison?
Yes.
And do you understand that that also requires lifetime electronic monitoring upon parole?
Yes.
Is it your intention in file 25 22117-FC to plead to the added count 2, another count of second-degree criminal sexual conduct.
Yes.
And do you understand the maximum possible penalty for that offense is, again, the same thing, 15 years in prison,
Yes.
up to 15 years in prison, I apologize. And the same condition with respect to the lifetime electronic monitoring.
Yes.
Do you understand that all of those offenses are also tier 2 offenses for purposes of the Michigan Sex Offender Registration Act?
I say yes.
So you have to be on the registry. Okay, so tier 2.
Yes.
So do you understand that that will require you to register on the Michigan Sex Offender Registration?
Yes.
Are you satisfied with Mr. Fry in the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct, Your Honor.
Mr. Fry?
Yes, that's accurate.
Mr. Goble, if a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Goble, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Not sure what he said. Okay. Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I have explained to you?
Not presently.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge in file 24-21915-FH that on or about November 23rd, 2021 to June 26, 2024 in the city of Adrian, county of Lenawee, that you did commit the offense of second-degree criminal sexual conduct?
No contest.
And how do you plead to the charge in file 24-21915-FH, again in the city of Adrian, county of Lenawee, state of Michigan, on or about November 23rd, 2021 through June 26, 2024, that you did commit count 2, a second offense of criminal sexual conduct, second degree?
No contest.
And how do you plead in file on or about August 4, 2005 through November 4, 2005 in the city of Adrian, county of Lenawee, state of Michigan, that you did commit the offense of, again, second-degree criminal sexual conduct?
No contest.
Has anyone made any threats or promises to you to induce you to plead no contest to those charges?
Anybody threaten you or promise you to enter this plea?
Not really.
Okay, not really. Has someone done something to threaten or induce you to plead
Sir.
guilty to this?
I got a phone call this morning. That was a total shock to me from my own son. I was not expecting it. So up to today, I had confidence that I could go to court about it. But now I have absolutely no witnesses, not even from my family. And I can't understand it. So it's very hard for me to say what should have been very simple. And I'm just trying to be honest about it.
That's fine. But I need you to understand that I can only accept your plea if it's given knowingly, voluntarily, and accurately.
I did.
Part of it being voluntary is that you haven't been threatened or induced improperly to plead no contests today.
No, I have not.
Are you entering these pleas of your own free will?
Yeah,
Do you understand that if I accept your plea, you're giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record here this afternoon?
That's right. Promise anything. You don't bring it now.
okay.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Goble to plead no contest today?
No, Your Honor.
No, Your Honor.
Mr. Goble, has your attorney promised you any particular sentence or estimated what your sentence would be?
No,
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I'm not sure. Just a second.
It's not really apply to you, but if you violate somehow the plea agreement. But it's not gonna really apply to you.
So what do I say? Yes,
If you understand that.
yes.
All right. You don't have a sentencing agreement, but the court rules require us to advise everybody of that right, regardless of whether it's applicable or not. Is it your own choice, Mr. Goble, to plead no contest today?
Yes,
All right. Ms. McClure, Ms. Fry, how are we establishing the factual basis?
Your Honor, I would just ask for a stipulation as to the police reports, and I can place those on record if there is a stipulation.
Would stipulate to using the police reports, Your Honor.
All right, go ahead, Ms.
Excuse me. Judge, I'll start with file. I don't know if my file number's right, 2521915FH.
Yes, please report.
These two things.
Oh, I'm sorry, that's FC, not the 25 file is FC. Other than that.
So 2421915FH. Only the one I think is FC. Okay, yeah, I should make sure.
Okay, I've got a 21916 and a 21917. No, I'm sorry. Okay, you are correct. It's 24-21915-FH.
Okay, so Your Honor, in this case, there are 2 counts of criminal sexual conduct, second degree. Count 1 as to victim AF and count 2 as to victim JF. The details of those charges are provided in City of Adrian report number 240013922 and was authored mostly in part by Detective Kevin Putnam. Though that police report provides that as to count 1, approximately 2022, when AF was age 11, that in the City of Adrian, County of Lenawee, at the defendant's home on Sand Creek Highway, that AF did stay the night at the home on Sand Creek Highway with Defendant Goble. That Defendant Goble started rubbing AF's penis over his clothes, and that was after rubbing him on his legs. He also was rubbing olive oil on his legs and slid his hands up his shorts and into his shorts and touched his penis. And in that case, Your Honor, the defendant was over the age of 17 when that happened. And that contact, as detailed, was done for purposes of sexual gratification. There was no other purpose for that contact. As to count 2, Your Honor, at the same location with the approximate date of offense of June 27th, 2024, when JF was age 12, defendant again being over the age of 17, JF was at his home again on Sand Creek Highway, and Defendant Goble was applying sunscreen to JF's back and stomach and moved his pants down while rubbing JF's thighs and genital area. The defendant moved JF's pants and underwear down to his knees and was touching his penis and testicles and moving up and down on his penis. And again, that contact was done for sexual purpose or gratification. There was no other reason for that contact. And I believe the report supports both of those factual allegations. So I would ask that the court find that the people met the factual basis has been met as to counts 1 and 2 for 2421915FH.
Mr. Fry.
We'll leave it in the court's discretion.
Based on the facts placed on the record and from the information in the police report, the court does find beyond a reasonable doubt that on or about the approximate dates of November 23rd, 2021 to June 26, 2024 in the City of Adrian, County, Lenawee, State of Michigan, Mr. Goble did commit the offenses, the 2 offenses in counts 1 and 2, each criminal sexual conduct in the second degree.
And Your Honor, as to file 2, again, correct me if I'm wrong on the file number 2522117FC.
That is correct.
As to that file number, the people would ask would offer the City of Adrian Police Report number 240013922, which was authored mostly in part by Detective Kevin Putnam. In the contents of that report, it would establish that a victim with the initials JP, who was between the ages of 11 and 13 at the time, that he did, victim with the initial JP did meet Defendant Goble while at the Maurice Spears campus in the city of Adrian, I believe, county of Lenawee. And later, after having contact with him and meeting him at the campus, he did go to Mr. Goble's home on Sand Creek Highway, and victim with the initial JP lived a couple doors down from Defendant Goble, who was over the age of 17 at the time. And through their contacts at the Maurice Spears campus, did have a JP over to his home, and JP did not want to tell anyone at Maurice Spears campus of any contacts with Mr. Goble at the campus because he was afraid he wouldn't be able to leave while being detained at the campus. But again, when he went to his house on Sand Creek Highway, Mr. Goble asked JP to pray in a bedroom and first did touch JP's genitals over his clothing when Defendant Goble had stood up and removed his own penis from his pants and took JP's hand to touch his own penis and used it to fondle himself. At the same date and location with victim JP, Defendant Goble did push JP's head and mouth onto his penis and forced it into JP's mouth. Those contacts were done for the purpose of sexual contact, and there were no other purposes for those physical contacts. And for purposes of the plea, the police report does establish that JP was between the ages of 11 and 13, and the defendant was over the age of 17, although the language is that the child, JP would have been between the ages of 13 through 16. I think it does establish he was at least 13 or less. And the people would ask the court to find as well that through the nature of the neighborly relationship after meeting at Maurice Spears campus under those terms, that there was some sort of authoritative position over JP. With that, the people would ask the court find the people have met the factual basis as to that charge.
Mr. Fry, anything you want to say with respect to that charge?
We will leave it in the court's discretion.
Based on the facts placed on the record from the information in the police report, the court finds beyond reasonable doubt that on or about August 4, 2005 through November 4, 2005 in the city of Adrian, county of Lenawee, state of Michigan, that Mr. Goble did commit the offense of criminal sexual conduct in the second degree. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Fry?
Yes, Your Honor.
I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Mr. Goble has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And set sentencing for February 5th at 8:15 a.m.
Your Honor.
Yes.
Could Phoebe send me the information sheet and the plea agreement, please? This was kind of thrown at me at the last minute, so I didn't catch some of it.
I will, Sarah. I'm sorry. I sent that to Mr. Jones because he usually handles these, so I apologize. I'll
Yeah,
forward it to
yeah.
you.
he's on vacation this week, so that would be great, but I'll also be handling it. So, I just appreciate it. Thank you, guys.
Thank you.
All right, Mr. Goble, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. Is there anything else we need to address today then, Ms. McClure?
Two things. One, Judge, I'm not sure exactly yet how many people would like to speak at sentencing. Did the court want to set it on a day when it has a little extra time, or do you think that day would be fine? I know you have a big trial coming up that's gonna take up a lot of time.
All right, well, let's go with February 6th instead of February 5th. I'll make that the only sentencing for the day.
Okay.
Ms. McClure, when you have a better sense of how many people may want to speak at the sentencing, then maybe we can have a quick conference with Mr. Fry and make a determination about whether it's going to be feasible to do it on that day, given whatever is going on in the trial at that.
That sounds good, Your Honor. And does Mr. Goble want to be present in person for that or on Zoom from the jail?
Mr. Goble, you have a right to be present in the courtroom in person for the sentencing hearing. If you don't want to be here, you can do it by Zoom from the jail. Do you know which you would prefer?
There's no advantage or disadvantage, whether you want to be in person in the courtroom or on the screen, just whatever your preference.
I'll be here in person.
All right, so we'll plan for that to be in person for Mr. Goble.
Thank you, Your Honor.
Anything else we need to address from your standpoint, Mr. Fry?
Nothing further, Your Honor.
Your Honor, we were here on a motion hearing originally. I would just withdraw that motion formally.
Okay. Thank you. That will be withdrawn.